I would also like to take this opportunity to read Ines Recio from Heidelberg Center, as this roundtable is a result of our mutual cooperation, and to thank the team from Partners and Integrity, led by Macarena Gallardo over there, for their support in organizing this event. The purpose of this meeting is to foster a constructive dialogue on the legal challenges companies in Chile face within the global context, particularly regarding third-party practices in supply chains. We hope the session will help enrich the understanding of corporate responsibilities and the legal risks emerging in the international arena. So we wish you a productive and enriching day. Thank you for being here, and we hope you enjoy the session. Now I will give the words to Annika.
Thank you, Cornelia. Well, my name is Annika Schüttler. I'm project leader of energy and sustainability at AHK Chile. And I will moderate today. I have the honor to moderate today. And the schedule is for the following. We will have a short presentation of 15 minutes of Professor Vella. And afterwards, we have a round table. Well, we have no table. We have a little table. So it's half a round without a table, but we will have a discussion round. So there, the idea is also that you could ask questions and that we have an interactive discussion with our panelists. So with no further words, I will hand over to Professor Vella. And the title of his speech is already on the screen, so I don't need to precise it.
Thank you very much. Thank you for this kind invitation and also for the organization. We are very happy to be here. We feel very honored. I'm also curious for the panelists to discuss this topic. Before starting in the substance, I would like to take the opportunity to show you two pictures of Heidelberg, the oldest university in Germany, with the almost same beautiful sky like here in Santiago. This is my institute where we are coming from, the Institute for Comparative Law, Conflict of Laws and International Business Law. We are also running this LLM program here in Santiago, and we are inviting all who would like to do a research stay there. So feel free to apply. It's informal to apply, and we have a lot of guest spaces. We welcome about 100 visiting researchers from all over the world every year. So this is our Heidelberg Center Latin America. Most of you knows it, and we are proud to have this LLM in international law together with our friends here in Chile. Now we would like to focus on a certain aspect. You mentioned it already, the impact of international law on corporate responsibility. And I would like to, I was asked to make a little talk about 15 minutes to show you some impacts of international law on corporate responsibility, then show you a current case of human rights litigation, and finally I would like to compare the supply chain acts in France and Germany, which are the most prominent examples of the European supply chain acts. So let's start with the impact of international law on corporate responsibility. Well, the starting point is the separation of private law and societal impacts. It can be traced back to the French Code Civil dating from 1804 from Napoleon. And here the famous Article 7 says that the civil rights, private rights are independent of political rights, meaning that you have two different spheres and that you have no corporate responsibility in that sense. We have a public-private law divide. And this was the prevailing opinion in the 20th century. Chicago School, Milton Friedman, the social responsibility of business is only to increase its profit. That's all, no further responsibility. And it was the prevailing opinion also in Chile, Pinochet, and in Europe. However, on the same time, we had on the international level a lot of treaties emerging, first in the sphere of human rights, and they were addressed, of course, to the states. However, there were then also the International Labour Organization and then the OECD, and especially the UN Global Compact, which had an invitation for big firms to collaborate on the global level and to respect human rights voluntarily. Not mandatory, but voluntarily. And the same holds true for the UN Guiding Principles of 2011, so-called RGGI principles, which addressed enterprises and businesses. And have a closer look to those RGGI principles. That's John Ruggie, the Vice Secretary General of the United Nations in 2011, who negotiated these principles. They have 3 pillars: the state duty to protect, the corporate responsibility and the access to remedy, and especially the corporate responsibility contains a so-called human rights due diligence. However, it's only a soft law approach, these UN guiding principles, and they had to be implemented by the national legislation. And that's where we are looking at in a few seconds. There was a second line. Also the first line was the human rights aspects with the RGGI principles at the end. And here we have a second line, that's the climate framework, also having an impact on businesses, starting in 1992 in Latin America, in Rio de Janeiro, with the United Nations Framework Convention on Climate Change, going on with the Kyoto Protocol and the Paris Agreement with the famous 1.50 degree goal, and with the European Green Deal, which transposed this goal, which is only addressed to states, into a framework also for businesses. So we have the human rights framework and the climate framework, and both nowadays in the last few years are also addressed to businesses. And here we have the recent EU legislation on corporate sustainability, starting 2014 with a non-financial reporting directive. This was a transparency directive looking at a disclosure of risks. Then we have the first directive stating a duty of care. It's a EU conflict minerals regulation. It was oriented or it was inspired by the Dodd-Frank Act of the United States, and it's focusing certain regions in Africa where those conflict minerals are gathered, Congo especially. It went on, the idea of transparency went on with the disclosure regulation and the taxonomy regulation, both trying to highlight the sustainability of businesses. Also the reporting directive, which is the succeeding directive of this non-financial disclosure directive. And then, very interesting, we have now the first substantial directive on due diligence obligations, duty of care, which was voted last year by the European Union. However, as you know, we have a little backlash at the moment, a political one, and it's getting difficult to establish such due diligence requirements, so that the European Union is thinking about a modification of this corporate sustainability due diligence directive by a so-called omnibus regulation, which is very recent, a few weeks old, and it probably will modify a little bit those aspects. So that's the European framework. And if we put it together, we have a movement from corporate governance to corporate social responsibility with human rights, to the environmental side and the environment, social governance, ESG. And in total, we can speak from a politicization of the corporation, or even from the law of the corporation as new environmental or new social law. So we have a fast development from the neutrality of private law, Code Civil, to the shareholder value principle of the Chicago School in the 20th century, now to the sustainability and responsibility of businesses for sustainability. And now I would like to zoom in and to show you one of the human rights cases in Germany. This is a famous case. It's by Kick. I don't know if you know that company, Kunde ist König in German. It's a textile discounter, and he produces his textiles abroad, here in Pakistan, with an independent supplier, Ali Enterprises Limited. And in this Ali Enterprises, there was a big fire with a lot of victims. And the question was, do the victims have the possibility to get damages? Of course, from Ali Enterprises, but this limited was turned out to be insolvent. And then they addressed the mother company. And the question is there a tortious duty of care of the company in Europe, of the KIK company, regarding the employees of Ali Enterprises? That's a big question. Here again with the chart. So we have here the victims, which are employed by the supplier and co-contractor, Ali Enterprises. But the question is, can they ask for damages to the parent company? And the question of today's discussion is, does misconduct in the supply chain, misconduct here of Ali Enterprises because they didn't respect the fire requirements, does this misconduct affect businesses in Europe or perhaps also in Chile? And one can say that this company is independent and is usually not affected. We have the idea of piercing the corporate veil in company law, but it doesn't work here in these cases. And the second approach would be a tortious liability of this company. However, according to the applicable tort laws, there is no such liability. In some countries, there is a vicarious liability, but not in Germany. So the question arises, is there a duty of care of this company towards the employees of this supplier? And according to the general tort law, the duty of care is only limited to the legal entity in question. That means this parent company in Europe has only a duty of care concerning its own employees in Europe, but not the employees of an independent subcontractor. So here we had a sort of shortcoming. And the question is, the supply chain acts wanted now to overcome this lacune and wanted to have a sort of liability of this parent company for the misconduct of this subcontractor. And that brings me to the third point here, the Supply Chain Act in France and in Germany, which I would like to show you only the big points. Because in France, it was the devoir de vigilance, which was enacted in 2017. Germany followed in 2021 with the Lieferketten-Sorgfaltspflichtengesetz, a little bit difficult. And now Europe, with the aforementioned corporate social corporate sustainability due diligence directive, is trying to combine these two legislations. If we look at a global map, we can see that we have supply chain due diligence laws in different countries. Especially here, France and Germany. And the idea of those supply chain laws, what are the common instruments? They contain usually a risk mapping obligation. That means you have to assess what are the risks of the business in case. And then you have to implement the first steps to mitigate those identified risks, to monitor the risks, and to report on it. That's the core of all supply chain acts. However, there are also differences in the different national legislations, especially concerning the types of enforcement and the scope of application. And if we look to the French Loi de Vigilance and to the German Supply Chain Act, you can see the differences. The French Loi de Vigilance addresses only very big companies, whereas Germany decided to address already businesses with 1,000 employees and more. That's a lot of more businesses than in France. The content of the duty of care is similar. We have a comparable content. We have the risk analysis, then to establish preventive measures. Usually we have whistleblower mechanisms and some sort of remedial measures. So that's the core of those two acts. I would like to show you a case of France, which is pending before the Paris courts. And it concerns an oil drilling project of Total in Africa, in Uganda. And the problem of this oil drilling project is that some of the inhabitants of Uganda had to be removed in order to be able to drill the oil. And this was established by such a construction. We have Total Société Anonyme Mousticine in Paris. We have then a subsidiary, Total Uganda. It's also a limited company, enregistered in Uganda. And then we have a subcontractor, a supplier. It's the Atacama Consulting Limited. And this supplier organized the resettlement of the inhabitants, which was a violation of the indigenous human rights. They have a protection here, and they didn't respect that. And now the question is Total SR responsible for the Atacama behavior here? According to French and German tort law in general, it is not, because they are independent companies. And now the question is, can you overcome that with the Supply Chain Act? And indeed, the French loi de vigilance establishes this duty of care, this devoir de vigilance, also to controlled companies and to suppliers, to direct suppliers. That means the duty of care, which is usually limited only to the legal entity in question, is extended also to the subsidiaries and to the suppliers. And the same holds true in Germany. It's even farther. It's the reach is farther than in France, because it also indirect suppliers are addressed by this Supply Chain Act. And if you look again now to this chart, you can see without this loi de vigilance, you wouldn't have the responsibility of Total SA, but with this loi de vigilance, I go back, you address the control companies and the suppliers, and that means you address this one, that's the control company, and that's the supplier. And that means the French Total SA is also responsible for the behavior here. And also for the misconduct, that was the question here of our talk, if this independent company does misconduct, and if Total SA would have had the chance to avoid it, to assess the risk and to mitigate it, then, and they didn't do it, then they would be liable for this violation. And this leads us to the enforcement. We have here in France, we have a private law enforcement, especially with injunctions and the civil liability of the civil code. That means a tortious liability for damages. In Germany, it's a public law enforcement where you can have penalties, Bußgelder. But both are, of course, a danger for companies, a risk for companies. So it's recommended that they observe the duties of care. So to sum up, we have slight differences between the two legislations, Loi de Vigilance and German Supply Chain Act. However, there are also common patterns, and the European Union tries now to combine both with this CSDDD regulation, which will contain also a sort of private law enforcement like in France. But it's very criticized by politics. So that's now the recent development here with the European Union, probably for all European countries to have this Supply Chain Act. Thank you very much for listening for my first little talk, and now I would like to continue the discussion. Thank you.
Thank you very much for this interesting introduction. I think there's a lot of Benja. Se cayó un vaso. Well, the show must go on. So I think I would make a short or small change if you let me, because I would directly invite to the discussion round. And the questions you have, you can just pose them in the framework of the discussion round, because then maybe the others can also give their perspective if you have specific questions. So I would then invite, first of all, Constanza Muñoz, who's Subdirector of Compliance of ENAP, a big oil and gas company of Chile. Then I would like to invite Juan Eduardo Ibáñez, Director of the Corporate Sustainability Program of the Catholic University, and Professor Vella. So, first of all, I have a question that was arising from your talk, because as such, the topic was international law on corporate responsibility, but I still see that it's at the end national law, or am I wrong?
Yeah, thank you very much. Excellent question. Well, we have international law, but it's not hard law. It's these Raji principle, the UN guiding principles on business and human rights, with the three pillars. And the second pillar, the duty of the companies to the responsibility of the companies. This is coming from international law, and then it was taken by the legislators in Germany and France, and they voted for a hard law regulation, which are the supply chain acts. But we don't have on the public international law level a mandatory framework for that.
There are no sanctions or anything in international law.
No, exactly. There are no sanctions in public international law.
And yes, well, you can also just talk. You hear us well?
Can hear us.
The Zoom. Yeah.
I want to add something. I want to first congratulate Professor Mark Vela for putting in a very simple way the development of this very complex law. And as he said, it's true that everything starts from the Napoleon Code, which is kind of a utopia, right? To divide the private and the public law. And today I think that reality is kind of getting under pressure. And you see that there has been many ways in where countries are trying to overcome this difficulty of the private law. So I will say that this is a soft law. Even in Chile, we don't have a law of due diligence, for example. But we already have different ways in which the state are trying to promote and put this into enforcement. So I will say, for example, three things. First, the agreement that Chile and Europe signed and that was enforced in last February include a chapter of corporate sustainability where they put due diligence as a requirement for foreign investment in Chile. So they expect that when foreign companies from Europe invest in Chile, they do implement the due diligence process. We are also including that in the taxonomy. So when Chilean companies want to go for debt or they want to issue a bond, a green bond, they will have to apply all of the standards if they want to be considered sustainable. And also we have a lot of regulation in Chile that protect women's in space of workforce and also the environment, that the only way to fulfill that is doing these processes. So at the end, what we are seeing is that we are trying to achieve the goal to embrace the public responsibility of companies, do different ways, and what that means overcome in some way this Napoleonian. I don't know if you agree or not, Professor, but that's my view.
You are the head of sustainability.
And I would like to stick to you. The new law on economic, de delitos económicos y ambientales. In how far does it also affect the supply chain, or is it only the behavior on national territory? I don't know if you can elaborate a little bit on that.
Yeah, so Professor, we have a new law in Chile that is enforced since last September that include around 200 penal issues into corporations. So it's kind of, we call the criminalization of corporate law. That is also another way where the government is trying to restrict or put more responsibility on corporations. So it's only focused on corporations, not in the supply chain, but if a contractor performs an act that can be considered like under the criminal code, it would be also responsibility for the company if it's produced some benefit for the corporation. Yeah, so it's more focused on contractors, right? If you have a project and you contract with a company to develop the environmental study and they do some kind of cheating, it's responsible the company.
Okay.
Also affect lawyers and consultants and everything. So I think it put more responsibility for corporations to take a closer look to the supply chain.
In the local supply chain.
On the local supply chain mostly.
Okay. Constanza, in view of what we've discussed, what are the motivations or the drivers that ENAP, as an oil and gas company, has today in the non-existence in Chile of a due diligence or a supply chain act? What is your motivation as a company to care about these issues along your supply chain?
I think that the key today is the word sustainability. Okay, we have a compromise with the social, corporate responsibility, and environment in our industry. That is a very, very big issue. So in the companies in general, it's very important to develop a due diligence process, including all value chain. So we have to understand, in the first case, why we want to develop this process, the objective of this process, and what we will be evaluated. For example, if we want to evaluate some business practices, ethical standards, financial situation, reputation, and we have to understand that the objectives of this process has to be in line with the company interest. And in this case, it's very relevant to understand that, for example, if my company has a commitment with environmental, and I have a specific supplier that has some environmental issues, we have to think carefully about that supplier. And if we want to have a contract with this supplier specifically. And in that case, my recommendation is to create a committee composed of compliance team, legal team, an area that requires that services, because we have to understand if we can reject that supplier, or maybe that is not possible because we have some critical suppliers, essential suppliers, or sole source suppliers. So we have to identify that situation. And I, like legal team or compliance team, we have to understand that the legal team should not be seen as a roadblock to the business. So we have to look for a resolution with another teams in the business and in the company, because we have to remember that the company is a business. So that is relevant.
But I still, so is it more sort of a social issue that you are concerned about your reputation? Because as such, legally, you're not obliged today to look at your supply chain.
Today, the principle of social responsibility and the environmental responsibility for my company is the focus, because we are developing a human rights due diligence process. So we have to understand the impact of our industry in a community, because in my case, this is very, very important because the impact are very high. So the focus today, if you ask me, is the social impact, environmental impact, in line with human rights, and all these things, thinking about sustainability. This is the big focus at the end.
May I ask you something? It's very, very interesting what you say, because you represent a big company, an influential company, and when you negotiate with those suppliers, and when you see, okay, there might be a risk in environmental aspects, can you also influence those suppliers in order to change their business model or to adapt? Because I understand that it's not always easy to substitute one supplier by another, because if you mentioned it, if it's an essential supplier or a critical one, but perhaps it's possible. That's the idea of the supply chain acts, to alongside the supply chain to influence at the end the different companies.
Thank you for your question. Yes, we try to develop a conversation, because I think that the transparency is essential when you have a relation. So even more, the last year, we developed an instance to explain to our suppliers this new policy about human rights, because our policy is new. So we have to explain to our suppliers the idea of this policy, our value or principles, because we want they understand what we want and why we need that they come with us in this compromise with the society in general, because we cannot do this, my company cannot do this, improving this line alone. So we need our supply chain in this situation if we want to make some change in the high level. So for this reason, it's important. And the most difficult situations is when we talk about the small suppliers. The suppliers that are located in specific regions. So in that case, we have to promote these values, these principles, and explain them what they need to develop business with us.
Juan Eduardo, on the national level, because you mentioned the incorporation of sustainability criteria and treaties with the European Union, do you see that those are drivers that also enforce then local or national legislation concerning these issues? Or do you see that has there been any impact in that sense at local level from the inclusion of these kind of disclosures in international treaties?
Yeah, it's a good question. We haven't seen yet, so I think it's very new. So we haven't seen that has been a driver since the last year. I will say that, as you mentioned before, reputation has been a key issue in Chile since we have this social upheaval in 2019. Companies really change. We in the university, we measured the implementation of the John Ruggie, how to say in English, is the guiding principles on business and human rights. We measured large companies in Chile. We took the companies who are open to the stock market and the largest public state-owned companies. And it has been incredible how they have been applying the standards every time more and more. So today we have around 50% of, which is very high. It's like Spain in terms of large corporation. And I will say that reputation is one of the key issues. The other one is investors. So today is also incredible how the large pension funds and other ones came here and want to see the real impact that they have in society and environment. And it's when actually it's incredible. We used to work with the legal areas within the corporation. Now the CFO is getting in charge of human rights. And when that happened, that's a real change because there's no way back. So I will think that investors is heavily reputation too. And also I think that the corporations in Chile realize that this is very important to get ahead with the projects. In a very complex and fragmented society, they need to explain what they are doing, what are the purpose, what are the impact. So I was invited 2 weeks ago to the north of Chile, where they opened the largest wind generation electricity producer done by Colbún. It's a large project, 800 megawatts, 140 towers, and they implemented due diligence in human rights. And they realized that was important to, we call viabilizar, like allow
Viable.
but make it viable. Make it viable. Otherwise, you will be fighting with communities. You will have labor issues. So it's very easy that they will stop the project if you don't apply these preventive measures.
I would like to take the 2 points. First of all, Constanza said, well, a business still has to be a business. But if we see these kind of things, it's just the risk analysis is the important thing of sustainability. I mean, it's not about being nice, but it's about understanding the risks that today are different from what they were 100 years ago. And that's a question to you, Professor Vella. Because I saw from what we read in the press and everything, all the companies claiming about, or how you call it, well, not very happy with the Supply Chain Act in Germany because of bureaucracy and everything. But as such, if we take it, maybe you can improve bureaucracy. But as such, it's a business intelligence to do the risk analysis. Because if I see the steps, how do you see, I mean, I don't know if you've perceived in how far businesses anyways value the fact that today, or they have done it even before the Supply Chain Act, these risk mapping. Has there been a change with the Supply Chain Act? And as such, it is something that responds to a intelligent business decision.
Yeah, thank you very much. Yeah, I think it would be a rational business decision, and you mentioned it that in Chile a lot of companies are following such a risk mapping. And however, what changed with the introduction of the Loi de Vigilance and the Supply Chain Act in Germany is that now it is mandatory for a lot of companies, and you also cover now companies which did not on their own. Yeah, exactly. And now they are forced to do it. It's a big industry, by the way, also because there are a lot of data points which have to be collected, and the reporting is a big industry of the accountant firms, which have now branches in that field and the specialization of that. Yeah.
So, well, maybe a little bit bureaucratic, but as such,
that's a problem. There's also bureaucracy with it. Yeah.
Yeah. Constanza, in how far today what are the main challenges that you have along your supply chain? I know that sustainability is a huge field, but if you say, well, these are the main issues that we have to focus on, that we have to take care of.
In general, as a big company, or when suppliers are big companies too on international level, they in general understand why they need, for example, ask for some documents for some compromise or some policies, because we ask them for that when we develop this due diligence process. But I think that the most difficult things is when we have middle companies that maybe they don't understand why we are asking about some criminal compliance program, or if we are asking about some specific declarations in different topics, because they have a different culture. But I think that this type of law, international law, and in Chile we are developing law in the same line, can help us, because they have to understand that like a big company, we have a commitment with the society and we have some principles, some values. But I think that the big issue is not the bigger companies and international companies in global level, or the smallest company. The situation is in the company that are in the middle, because they ask us, why you're asking to me so these declarations or this information, this is not important, but for us it's relevant. So this area is difficult for us, but in this level. So in this case, to try to resolve the situation, the most important things, as I said before, is the transparency and the communication. Explain to the supplier why this information is relevant for us, for a law, for example, in the case that we are talking about global industry, global companies. But I think that the explanation and the transparency and explain the reasons, I think is the key point if we want to maintain a good relations with the different type of suppliers, including thinking about the type of industry or the service that we need. So this is very relevant.
Do you also help the suppliers?
Yes, we try. When, for example, if they don't have some policy, we told them why we need it and how they can develop these documents or the procedures, or maybe we can develop a risk assessment to understand the level of the risk, and they can understand too. So yes, we try to help them.
Well, we've already mentioned, or you have already mentioned in your talk, that at the moment the political scenario internationally maybe is not so favorable to support more supply chain acts as such. Now we see that as such business maybe is even more ahead than than local legislations, because there's a conscience that they need it. But if you could say, both of you, what is the tendency in international law? Because at the moment the only thing I see is national law. So what is the tendency in national laws and international law as such, as a sort of a major framework? What do you see? It's not easy to say at the moment.
Yeah, there's a lot of uncertainty. So in Chile, the government is working a project of due diligence law, but I have doubt that they will send to Congress during this year. So I'm not sure. Maybe they will. I'm not sure. They are working now in the National Action Plan on Business and Human Rights that need to come in place this year. And let me add also that there's some decisions from the Corte Interamericana de Derechos Humanos, the Human Rights Court in Latin America, that address some of this issue when they have some responsibility from the state. And they are also looking for due diligence as a way to make companies to see as a threshold if they are responsible or not. So also jurisprudence is another way that they have been implemented, right? So saying that, I think that it's very difficult. I believe that in Chile, we move ahead with this law because we have a problem of competitiveness, productivity, and also a lot of regulation. So this is the topic right now in Chile. We call permisology, because for example, a gas company that we work with, they have 4,000 regulations that they need to fulfill. So the map of regulation is 4,000. And they say, you want to add more, you will kill the business. So we have to think about that. But also, I think that the sustainability need to give the test and prove that is also add productivity and competitiveness for companies. And that's the point that we are right now, right? And for example, if you see the last bit of energy that have been done by the mining companies, they are also asking for human rights standards for the bidders. So it's important to be able to do business, to include that. So I don't think that at the moment there will be new regulation. It's very uncertainty, but companies are continue working on that. So there will be no step back in terms of risk assessment, for example, right? So we will see what's going on.
Yeah, exactly. That's what I would also say for Europe. We see a sort of ESG backlash in some parts, and it has to do with bureaucracy because there are also too many data points which are required, and we will have their movement back. We just discussed a few minutes before we started here the coalition agreement between, in Germany, the new coalition agreement between CDU and SPD. They indeed agreed to abolish the Lieferketten-Sorgfaltspflichtengesetz. But what will remain is the European regulation, and it will be like you mentioned it. The big companies has also advantages from this development, and they won't roll back the whole process. There will be less bureaucracy, but the main points, I think, will be maintained: the risk mapping and the mitigating of those risks.
I have now a last question to Constanza before I open for discussion. And I also have a question from someone who's participating online here. How do you as a company organize? What is the organizational structure with which you confront or with which you deal with all these issues? Because, I mean, you are one person, there's a lot of issues that are involved. How do you do it organizationally speaking?
No, we have a team. I am part of that team, but we have distributed the issues. So in general, for example, I watch specifically some today data protection is a new program, and human rights. We are developing the due diligence in human rights. This is very difficult in our industry. So a criminal law to the company responsibility in criminal issues. And I think that this is very relevant because we have a team with different professionals in different areas, and we work with external consultants. So I think that they can give to us the specific information in that areas, but I think that the first response is ours. We have to, if we have some emergency, the first response is of our team, and we have to answer that question about the board, for example, the other managers. In the general, the most typical questions about the area of sustainability or social responsibility that have relation with the communities or with society in general. And the area that buy the goods, the different goods, and how the goods arrive to our country. I think that in general, this is a type of an emergency, but our team has this first answer, but we have some consultants to ask questions.
And in the company, do you do actions that everyone is aware? Because at the end, it's important that there's a sort of an organizational culture also that supports what your team is doing, no?
Yes.
How do you organize that? That people are all aware, that they also alert, or that they also give you the data that you need?
They give me the data I need and ask them for information for a specific process, because we have the processes are more risky. So we have to understand that, and we help us. And sometimes we modify the process to apply a new soft law of international law, because we have to be in line with that. Like a big company, we have to understand and we have to study the international law. For example, in the case of the due diligence and human rights, we are watching the international regulation and the soft law. And that is, I think, the most important thing, the communication between the teams. And for this reason, we have a different committees, not only for the due diligence process, to take different type of decisions about the business when the compliance opinion is relevant because the situation represents some risk. We create the different type of committee. For example, if we have some conflict of interest with some supplier, or we have a politically exposed person, we have to take decisions. And in this case, we have to incorporate different areas to take this decision and analyze the situation carefully.
And then I still have one final question. How long is, for example, you mentioned the case of Total Energies. How long do they already have this lawsuit? And how long are these conflicts in general taking in the court, on the court level?
Yes, usually they take several years because it's not only limited to the first instance, it's also the Court of Appeal and the Supreme Court, usually in such important decisions. So it takes a long time. Often companies, however, want to settle such claims and try to negotiate then with the NGOs, especially in such oil drilling projects or similar projects. If they are ongoing, it's always better to settle it and to avoid such conflicts.
So now, any questions from the audience? Wait, I will give you the microphone, otherwise.
Thank you so much. First of all, thank you very much, Dr. Vella, for the very interesting introduction, starting with the French Civil Court. It was very interesting. But I have a question to Mrs. Munoz about the operations that is doing ENAP outside of Chile. Are there any special requirements or special things you are watching or you have to be aware with you starting projects out of Chile? I know you had, for instance, one project in Argentina, Vaca Muerta, but I think you don't have it anymore. But I can imagine, according to the regulation, that is very different in a lot of other countries of our region, Latin America. What are the special requirements you have to watch if you're doing projects outside of Chile?
Yes, in Argentina, we are closing the operation. That we study, and we as compliance team study the project, if the project has some risk, okay, in specifically. Today, we have a lot of new projects we are developing, where I think the management are thinking about a new project in another country, okay? But in general, we analyze the type of service, what they need, the regulation, the specific regulation, but we try to develop a project with high standards and ask to our suppliers that they have to comply that standards, and we start with the due diligence process in our different suppliers, depending on the type of supplier we are talking about. In some cases, it's possible to continue with our current suppliers that can provide the services about this new project. In that cases, maybe we will have to make an update about the due diligence process if we change some topics in our process, because we always change the process to increase the level. So in that case is relevant. And if we are talking about new suppliers to this specific project, we have to analyze from the beginning. So searching if this supplier has some negative findings, if we can take some mitigation measures, maybe if we have another options. That is the idea. But today, we don't remember that a big new project, but maybe in the future we will have, because we close the operation, we're closing really in Argentina. But today is the same process about due diligence for our suppliers in all projects. So, but in essential, the idea if we can to contract with the same supplier for a big issues, a big project, the idea is to maintain that relation, making an update. And in the specific region, maybe my recommendation for the project is try to contract some maybe local companies and work with them if it's possible, because we are talking about sustainability and that can help us in this line.
There's another question from Danilo Granato, who is participating online, and he says, thanks for the great discussion. What implications might the European supply chain laws have on Chilean exporters to Europe? Are there increasing demands for Chilean suppliers? Are there opportunities for suppliers to have help from foreign companies to mitigate their risk? That's the question from Danilo. I don't.
Yeah, thank you, Danilo, for the question. I think it has a lot of implication, and I think it has been a driver for how companies are producing right now. So what we are seeing is the German companies who operate or buy products in Chile are imposing the standards to local companies, and that's real. They are not only asking for the checklist, but they are visiting the sites, and they really want to be sure that they apply. We are also seeing that in the case of lithium, for example, and the car makers are buying lithium for batteries. They are really asking a very high standard for Chilean companies. Actually, SQM and Albemarle, the two companies who produce lithium, are getting the IRMA certification, which is very high. And IRMA includes all of what we have been talking about. They include human rights, include due diligence. So that's a force for good for us. But the other thing that I want to mention is that I don't know how the thing is in Germany, but in Chile, companies are very heavily rely on contractors. So I visit a mine, sitting mine, and you have from 1,000 employees, only 200 are from the company, and all other ones are contractors. So I don't know if that's kind of specification that also happened in Germany, but here, that's a huge risk because you have people operating your site, living with your own people that are from other companies. And that's one of the big risks that we see here. Respect for human union rights, human rights for indigenous community, violence on the workforce. So I think it's good in terms of that they are level the standards, but also we have to see very closely who are responsible, who owns the corporation, and what happened. And for what Professor Vela is saying, in Chile, we have also a new law that protects women in the workforce, and that also apply for people from other companies who can affect your own people. So if a third party make an act that is a disagreement for a woman that work with you, you are liable if you don't have the processes and the standards and the cultures to protect them. So again, we are seeing how law trying to open the responsibility for act that even you don't have control of it.
Well, that's in general an interesting issue because we're talking about global supply chains or whatever, but obviously there's one supply chain that's the local supply chain. If your subcontractor has bad conditions or whatever, which is something that in general the difference in wages, etc., in the mining industry are also big between subcontractors and the industry. I mean, that would be the first thing to look at. So, any other questions? Yeah, first, then you.
Thank you. The two largest economies in the world are the United States and China. China is well known for not being very careful about their human rights, among other things. And the United States, well, we are seeing what's happening right now, where the current government is trying to undo many things that have to do with these kinds of laws. In your opinion, that the two largest economies in the world are not necessarily complying with this kind of approach, will that have any impact in the future in terms of changing the rules of the game, so to say?
Yeah, it's a good question. It's a reality check. Right? Well, I think it's true that what you mentioned in the US, that there's a cultural war about ESG and wokeism and everything. But our experience that it's that American companies are really they are continuously respecting human rights. For example, if you see Tesla, that is a very company that you will say very vocal against ESG, and if you're going to see the report, they identified salient issues in human rights. They transparent all impact. So I live in the US and I know that they don't talk a lot about this, but they're very focused on respect human rights. And they have a very active judicial system where if you have any problem, they will look at it. Right? Actually, we launched the sustainability programs once Nestle was sued in the US for human rights violation in Thailand. You remember the case. And in that case, the Americans very practical, do the company know, or they must know that you are doing some kind of abuse? And they don't care about all of these subsidiaries and stuff. They are very practical in that term. So I don't see that the American companies or American investors are going to go back in terms of risk assessment and ESG analysis. China is a different animal, right? And I know that they pass in different countries. Sorry, they passed regulation for foreign China investment overseas. They also want to protect the reputation. I'm not sure how they are accountable for the level of transparency, but I know that they are applying now this directive to foreign investment overseas.
What I see is that just sometimes we talk about sustainability as if it was something that is only a burden, but I anyways want to stress once again what you said is a perfect example. The US, there's a business case behind it. So that's why they are practical about this and they do it. And I think any company that is intelligent will do this. Yes. The bureaucracy or something like that, this is, I think, sometimes the most important issue. But as such, yeah, well, in China is a different case.
And I want to complement that, saying that this is opportunity for the companies to demonstrate the real commitment with these topics. And it's not only to comply the law. So I think that is talk about the reputation of the companies, the principles and their values.
Yes. Joaquin.
Thank you very much, Annika. Once again, thank you very much for the discussion. I have a question regarding Mrs. Munoz, because before you said that you implemented a public commitment over business and human rights and perform human rights due diligence and so on. My question is regarding, it's quite basic, but I want your opinion. It's like, what is the legal content of this document, this policy commitment, and the perform of these processes? I ask about the legal content because I want to know your opinion, whether if you don't comply whether with this document or these processes, you don't fulfill all the obligations you voluntarily committed to, because here in Chile we don't have a regulation over the topic. Do you see risks whether you don't comply with it, or sanctions, for instance, or tort law, or an environmental agency who would seek to punish, for instance, these breaches of this document or the process?
Okay. We change the process in general about including the human rights. I am talking about the due diligence in general of our suppliers, including this topic, because this is a new topic. And in the first place, we create the policies. The context of the policies that we have to include soft law, international soft law. In some cases, it's very difficult to ask to the supplier for if they comply this policy of the soft law, because it's soft law. We don't have sanctions. So I'm not thinking about of labor law and other things that we have sanctions specifically in that case. So we include in the contract, the sanctions are included in that way because we don't have, we cannot start some demands or trials for that. But we include in the contract like a sanction, and if, for example, this supplier has some human rights issues, we can finish the contract, and we say it specifically, and we have to be clear about this point. and say, okay, we have a new situation, we have a new commitment with our stakeholders, and we need that you respect this point about human rights. And we develop the policies in very general area. So, on the other hand, we develop this due diligence process about human rights, and the most important thing is including the process to our supply chain. We ask to our employees and our suppliers about this topic, what they're thinking about, why they think we can do about this, why, what they think or how our industry can affect the human rights and the impact. And we work in that line. But in general, as your questions, we don't have another way to regulate the situation. We have to include only in the contract and talk about a lot in different instances, on seminars with our suppliers about this topic, because we need today understand why this is important now, specifically for our company, and why we want that they come with us in this new challenge. Talking about the new international regulations too, because this situation demonstrates that the world is changing, and Chile probably will change in the same line.
Any other questions? At the back, we have a question. I will go there.
Thank you very much for the discussion. I think that the challenges that we have, like a foundation of the topic, is how we change the idea for the company to continue doing business as usual. I think that the thing is, business as usual is a topic, and because they change. I'm very happy to hear good news for the company. I'm very easy, but the idea is how we change that, and there are many ways. In one way is make it mandatory or by voluntary way. I don't know, maybe at the level of the state, because we didn't talk about the state. Another thing is international law can do something, but the thing is how we convince the company to change the business usual. I think in that way, do you think that it could be possible?
I think that's a question for the three of you.
Yeah, maybe the law hasn't changed, but the reality of the country have changed so much in the last year. So for me, something that it has to do with the survival of the corporation, right? When you see now what happened in the territory, we don't need to go to other countries. We see a lot of change in terms of migrations. Security issues are very heavily right now, health and for employees. So for me, the due diligence process is a way to understand what's going on in the context that where you operate, where are the new risks, and how to prevent them. So what I will do to change the company is to invite the board to visit the operations, to talk with the people, and they will give you I don't know what you think, Professor Bell, about that, but sometimes the law going very far beyond, right? Reality change, people face new challenge. And honestly, for me, waiting for a new law to apply this is kind of a loss of value for corporation and society.
Okay. No, I want to only compliment that today the society is expecting the behavior of the companies. So this is not only, we're not talking about only about law. We are talking about what the society wants or is expecting of the companies.
Exactly. That's what I wanted to say. It's an expectation of the general public, but also an expectation of the employees. They want to work in companies which respect the climate issues and which respect social aspects. It's not cool to work in a company who disrespects those aspects. So indeed, we have also an expectation level, and what you said, it's independent of the legal framework. The legal framework comes usually after the expectations and backs these expectations, but it's the expectation, as you mentioned.
And if I also got that something is that something that we learn from mostly from American companies that and and the legal function is changing there. The true question is not only what is legal, but what is right. And that's something that we have been working in the Universidad Católica to train our lawyers to make that big question within the corporation, right?
Closing.
Yeah, well, it's in general, and I think we always have to remember that companies are made of people, no? So, I mean, we sometimes talk about corporations as if they were another person, but corporations are made of people, and if people are more conscious, then I think things also change. I think we have a last question. You had a question?
I have one question to Dr. Weller. There have been recently complaints from the US government that in Germany are the human rights not well respected, especially when it goes about liberty of opinion. It cannot be that somebody is publishing something in social media and as a consequence he has to go to jail. Especially the vice president of the United States made these complaints. For two questions. The first, what do you think about these complaints? And the second question would be, could there be a real impact of German companies and German businesses because of this kind of complaints?
Yeah, thank you very much for this question. Well, in Germany, we have, as you have here, the freedom of speech. It's the same as in the US. Of course, there are limits to this freedom of speech, and one limit is, if you injure another person verbally, so that's not allowed. But the second part of your question was, does this opinion of the United States, which was formulated by the new administration, has an impact on German businesses doing business there? Well, I don't think so. It's because it's as I said, we have this freedom of speech, and it's generally accepted by the rule of law. So I don't see the issue. Yeah.
Okay, thank you very much. I think we're coming to the end, and from the Chilean German Chamber of Commerce, we can only say that there are many companies that don't wait for laws. We have two programs in the Chamber of Commerce. One that work with integrity, Alliance for Integrity. We have a program that helps companies developing their sustainability strategies and reporting, and we have many companies that join in, that are working with us, and I think this is sort of a sign that law is important, but there's a traction that goes beyond law even. So thank you very much.